Members, this is the Subcommittee on Inland Revenue Exchange of Information Relating to Taxes USA Order. This is the first meeting. We have a quorum, and this is the appointed time. First of all, we need to elect a chairman. Any nominations? Yes? Mr. Leung? I nominate Mr. James Toh. Any seconder? Mr. Andrew Leung, seconds. Any other nomination? All right, no, thank you. So I'll continue to chair the meeting. Let's invite the administration in. Sorry, Mr. Christopher Chung applied out of time to join the subcommittee. Members of this subcommittee, any objection? No? All right, so let's welcome Mr. Christopher Chung to this subcommittee. Oh, next, housekeeping matters. We have the PWSC meeting in the next room, and it is possible that after voting on whether to discuss certain amendments, they may proceed to voting on the landfill extension and incinerator proposal. And I think many members of the PWSC, including myself, will have to go there and vote. So I will suspend the meeting here and go to the next room to vote and come back. So just to tell you in advance and to reach consensus, the meeting may be suspended in a moment. And also for the administration's information, next door we have this PWSC meeting, and they may vote on the major proposal. And I've told members that by then we may have to suspend this meeting for a couple of minutes, and members of the PWSC will have to vote there before they return here and resume the meeting. So this meeting may be suspended for a few minutes.
Oh.
So let me introduce the government officials representing the administration. We have Ms. Shirley Kwan, Principal Assistant Secretary, Financial Services in the Treasury, Mr. Chiu Kwok-hui, Deputy Commissioner, IRD, and Mr. Jackie Liu, Principal Assistant Secretary for Financial Services in the Treasury, Ms. Alice Choi, Senior Government Counsel from DOJ, and Ms. Emma Wong, also from DOJ, Senior Government Counsel. So I'll first invite Ms. Kwan and your team to walk us through the paper. Thank you, Chairman. Now, a brief introduction. Now, this exchange of information relating to Taxes USA order, the goal is to implement the relevant EOI agreement signed with the U.S. In March. And we need to go through a negative vetting process in this council before we can implement the relevant agreements in our local legislation. Members may recall that in the second quarter of last year, the administration proposed some legislative amendments to amend the Inland Revenue Ordinance so that we can keep up with the latest international exchange of information standards. That is, apart from the CDTA's comprehensive agreements for avoidance of double taxation, we also arrange for tax information exchange agreement, TIEA. And at that time, we highlighted the administration's objectives. And I want to emphasize again that our focus is on CDTAs. However, the current international standards are that for jurisdictions which turn down our requests for CDTAs despite our repeated persuasion, in order to meet international requirements, we will start discussion with them on TIEA, Tax Information Exchange Agreement. And after the scrutiny last year, since July, Hong Kong already has a legal framework for the signing of TIEA. That is simply for the exchange of information. This is the first TIEA submitted to this Council since the establishment of the legal framework. And about this TIEA with the United States, as said just now, the situation is similar. All along, the Hong Kong government has been striving to sign a CDTA with the U.S. However, so far, the U.S. has not shown any interest in pursuing a CDTA with Hong Kong, and also to tie in with the international standards. And also because the U.S. will be implementing the FATCA, the Foreign Account Tax Compliance Act of the United States, soon, which will take effect on the 1st of July this year. We see an urgency to sign a TIEA with the U.S., and it is time critical to do so for the financial institutions in Hong Kong to comply with the FATCA requirements to lower the compliance costs and alleviate their burden. The TIEA proposed here was mentioned in the press release last Friday. It is concerned with an IGA, intergovernmental agreement between the Hong Kong government and the U.S., and both complement each other. Now we provide a framework so that if necessary, the U.S. tax authorities can make an EOI request with the Hong Kong IRD. And in relation to the TIEA, I can say that comparing to the framework under CDTA, both are quite similar. I wish to highlight some salient features, and that is in our LegCo brief. These features are set out. Under this TITA, we are going to adopt the OECD version. The OECD has prepared TIEA models. And previously, we gave an undertaking with the Legislative Council that in order for taxpayers to understand the scope and the tax types of the TIEA, we have adopted a positive listing approach to set out the tax types covered, both in the U.S. and in Hong Kong. And as mentioned in para 10 of the LegCo brief, similar to the CDTAs in the past, we will adopt highly prudent safeguard measures to protect the privacy of taxpayers. And may I repeat these measures? For example, we'll only exchange information on request, and the information sought should be foreseeably relevant to the enforcement of tax laws, etc., before we accept such a request. And the information exchange will only be carried out after the if the information is generated after the effective date of the TIEA, and the information should be treated as confidential. And for example, information covered by legal professional privilege, there will be no obligation to supply such information. As for tax examinations abroad, we will not entertain any such requests. As mentioned before, on monitoring, the information disclosed would only, or exchanged would only fall within the scope of the relevant contracting parties, the tax authorities, except when there are justifications. We will take a positive listing approach as far as the tax authorities are concerned. And in our agreement, we have set out the relevant law and tax law enforcement and the agencies involved in the TIA with the U.S. Which are set out in Para 10E. And one thing different from the CDTA is that we have a provision concerning the general costs. For the costs generated in processing the EOI, the contracting party will be responsible for the costs. That is the ordinary costs incurred in providing assistance. And it will come into effect on the 20th of June 2014. Maybe I will stop here, Chairman, and I will be happy to answer members' questions. I'll ask members if you'd like to have any time limits. According to my past experience, I don't think we need any time limit. I will keep watch of the time, Mr. Andrew Leung. Now, this order is prepared to tie in with the relevant U.S. Act. Is there any choice for Hong Kong? Say, if the agreement is not signed, all the business enterprises in Hong Kong, financial institutions in the U.S., will there be rise in the compliance costs? In the past, we signed CDTAs, which are bilateral and which are beneficial to Hong Kong. Whereas for this one, this is unilateral, and we normally will not ask for any, will not launch any EOI request with the U.S., whereas the U.S. Seems to be forcing this on us, on our financial institutions and banks. So the business sector thinks that it is unilateral. We used to have other EOI agreements, which include safeguard measures, and any aggrieved party may file a claim with a court of law. So what is the difference between this agreement and the CDTA? The other question is, after signing this agreement, the purpose should not be for lowering the compliance cost of certain financial institutions, but all companies in Hong Kong. We had discussions before. We asked whether the U.S. government would embark on a fishing expedition and what safeguard measures we have to stop this from happening. Although you say we have a positive list, we need to go through your list and see whether there are sufficient grounds for them to do so. For example, in the commercial and industrial sector, we may have deals with the U.S. counterparts, and apart from the trade, there may not be nothing else. And will information belonging to our company be sought? On cost, the request or the applicant party will bear the cost. Does it mean that the U.S. tax authorities will be responsible for the cost? What if they don't pay? And for companies which is subject of any EOI request, are there any procedures for them to reject the request?
We have asked this in other venues and other acts. Well, first of all, at the policy level, Hong Kong have any room to not sign TIEAs? Is there any benefit to Hong Kong? In the past discussions, whether we need to set up a TIEA framework discussion, we had dealt with this. Our policy focus is to sign a comprehensive agreement, but currently the international standards have evolved. You can attempt to persuade your partner to sign comprehensive agreements to benefit your economic development, but if ultimately, if your persuasive efforts cannot include tax relief or other tax information exchange. Last year, we were very happy to receive LegCo support to endorse the legal framework. Now, as I said in the beginning, we have at different government levels and American Chamber of Commerce, we have maintained communication. They understand that in the past we had wanted to sign a comprehensive agreement with the U.S., but currently, to answer your question, is it just because of FATCA? From a broad tax cooperation agreement, the comprehensive agreements and TIEA both have to be balanced. You cannot agree to one and refuse signing of the other. It's just that FATCA is an extra consideration, and there's a certain sense of urgency. Another issue is, it's the same for other parties. If we sign the TIEA, it won't obstruct our persuasive work. If we do have double taxation, and if we need to demonstrate to the other party, signing the TIEA does not preclude the negotiation of a comprehensive agreement. We can continue these efforts. At the operational level, under the TIEA, in light of requests, and the IRD will seek this information, there's no difference. Currently, we reiterate that this information, this information has to be retained according to our Inland Revenue Ordinance. There is the requested party can respond to the IRD that they don't have the information if there is a reasonable cause. We also have to comply with the disclosure requirements. We have to avoid phishing exercises. This is exactly one of our disclosure principles. If our counterparty put forward a request, they need to demonstrate that they're relevant causes, so that the IRD can decide whether to accept their request. Regarding the costs, we have listed whoever raises the application. If it includes non-recurrent costs, large costs, then the requesting party will have to bear the cost. Let's say if it's the U.S. that raises the request, then these non-recurrent costs will be borne by the U.S. At the actual operation, the IRD they have some mechanisms to handle this. Could you refer to paragraph 11? Why do we have research costs? What do you mean by research? So allow the IRD to respond. Thank you, Chairman. Regarding the costs, under TIEA, the general costs, assuming it's the U.S. making a request, the general costs will be borne by Hong Kong. But if there are special costs, that is larger amounts, or the U.S. has special requests, for example, they need special handling, Hong Kong can ask the U.S. to bear the cost. Could you elaborate? What do they need to pay for? You've given some examples. Translation, and research. What do you mean? And if you ask me what accounts, well, if I have it, then I can show you. TIEA is something new. We don't have actual experience, but my understanding is that experts involve evaluation. And we need a professional surveyor to conduct, and that would involve expert costs. You have a specific request, and they tell you that the tax information of a certain company. But why do we have valuation? Now, let's say a company sells antiques in 10 million. You just report this information. We don't need to. Why should we provide an expert? The simple case will not involve experts, but we have related transactions to companies, Hong Kong and U.S. companies. They might be related. Their pricing might not follow market mechanisms. We need someone to assess the value. Well, you're providing information. You shouldn't be helping them investigate. You shouldn't be assessing whether this is a legitimate transaction and so on. Well, if the U.S. wants to know a market price, they have reasonable conjecture. Well, they can get a law firm. We should engage these people and charge them. So I agree. Unless we're forced, we won't take on this extra work on their behalf. Well, first of all, you're just taking what the IRD has and provides, and provide this to them. You shouldn't do anything else. You just need to verify that this is information that you collected legally in Hong Kong. Then I have a follow-up question. Just now the Secretary said we have a OECD template, and I know the U.S. has a lot of requirements. You need to point out what is different from the OECD template. You don't need to answer now, but I would also like our legal expert to find this information and make a comparison so we can have a focused discussion. Okay? Before I'd like to follow up on Leung Guan-yin's question. Could you tell us which article has been changed? Could you tell us what articles are amended in the OECD template? You have been working on TIEA for a couple of years. I'll elaborate and broad details. If you look at the provisions of the OECD template, they need to take care of bilateral TIEAs, including multilateral TIEAs. So some provisions handle multilateral, so it's not applicable in our case. If you just look at the number under the OECD template, they have 16 provisions. And if you look at this US Act, we just have 11 provisions. So, as I said just now, some might not be applicable to Hong Kong. For example, they have other international agreements or arrangements, depository functions, implementation legislation. We need the local laws. And just now I mentioned 3 items. A multilateral provision is not applicable, and the 5th provision that not included is the tax examination abroad. Under our TIEA, we will not allow foreign investigation, so we have repealed this provision, so both sides don't have this responsibility. So I'd like to ask, you said you repealed the tax examination abroad, so are we doing the investigation, or they're sending people to conduct an investigation? This is a bilateral agreement, so the spirit of each arrangement is bilateral. It would be a bilateral arrangement. So are we assisting them, or are they sending people over here? We can assist them, and if we make a request, they can also assist us. So even without this provision, I am aware the U.S. Embassy have a team doing tax investigation in Hong Kong. I'm not sure if you know. The U.S. IRS, they have a team in Hong Kong doing investigation. So could you provide some information on this? So even if we don't have such an agreement, the U.S. IRS, they might be attached to their embassy. They already have people in Hong Kong conducting tax information collection. It's not a secret, it's open. So what is your question? So well, it's related. Even if we don't have this agreement, they are already collecting information where the public is not aware. So what is your question? You're stating a scenario. Have you received this information, or are you aware that this is what the U.S. government is doing, and if they're doing this under this legal framework, even with this agreement, is it legal and is it in compliance with protocol?
Thank you, Chairman. At the government level, we have not communicated with any staff of any tax authorities of the U.S. Consulate's office. So she's answered there is no official dialogue on assistance. I think you are not going to answer this question, but I want to point out this fact. They have people on the spot gathering tax information, but the Hong Kong government has no communication via the official channel. I just want to bring up this point. our tax information is being gathered by the counterparty one way or the other. So much for my question, Chairman. Now, let's say if this is passed, the counterparty or you're going to contact the counterpart in Washington instead of the relevant tax authority here. I won't say they have a branch here, but there may be people, staff here, and maybe there will be contact via email. Chairman, as far as the whole agreement is concerned, we have a competent authority. For Hong Kong is IRD, for US it is the Treasury. All right, so do you mean the Office of the Treasury in the US? Yes. The provision sets all its delegates. That means any officials in the Office of the Treasury. Is that right? I think the IRD will need to receive authorization or information regarding authorization before before he complies with the request. So there will be some exchange of information requests. Has there been any occasion in which the delegate contacted or one of the representatives contacted us? For the CDTAs signed, all the competent authorities refer to the governments in other jurisdictions in the capital city, and it is our government that contacts directly with the competent authorities. So there have never been occasions that they got in contact with their consulate in Hong Kong. Mr. Christopher Zhang. That means brokerage firms will also need to comply with the agreement. That means if you have a client of U.S. nationality and if there is no declaration, then there will be a 30% withholding of the assets. Yes, it's footnote 2. So it's a 30% withholding from the deposits in the client's account or the estimated value of the client's securities. And we also have a confidentiality agreement with our clients. We have this agreement at the time of opening an account with the client. So if we receive any EOI requests, is there any mechanism for us to raise objection? Now, for the first question raised by Mr. Zhang, this is to do with withholding arrangement in advance. Now, this doesn't stem from TIEA, but rather from FATCA in the United States. That is, for clients unwilling to provide information for such accounts and withholding arrangements, maybe Mr. Liu from FSTB can further supplement this point. After disclosing such information, as I understand, the financial institutions would have to seek the client's consent first. So if the client refuses the disclosure, there is no mechanism to compel the client to provide such specific information. So it has to do with the FFI signing agreements with the U.S. Under FATCA. There will be such requirements imposed. But we're now talking about the exchange of information mechanism between tax authorities. So these are two different matters. please answer Mr. Zhang's question on para 5. You said that because there is the FATCA in the United States, and it has not to do with the TIEA or the exchange of information order here. But why have you included it here? There must be some link. Please explain to us. If you say this is not relevant, why have you included para 5? Thank you, Chairman. Well, it is time critical to have this, and it's also complementary to each other. That is, to meet the requirements under FATCA and to save the FFI's costs in compliance, we need to have IGA's intergovernmental agreement, and there are two versions. The first version with the U.S. is that at the first stage, between governments, the Hong Kong government has to proactively supply information to the U.S. government. And we have adopted version 2 of the EITA model, and that is the financial institutions in Hong Kong will have to report to the U.S. first regarding any information of U.S. of accounts held by U.S. clients, and if necessary, under the TIEA framework, the U.S. tax authorities may file EOI requests with the Hong Kong tax authority. I hope, Mr. Christopher Zhang, you can follow up on this question, because Mrs. Guan is saying that originally, regarding the FATCA in the United States, all the financial institutions overseas, including all the FFIs, including securities firms, will have to report to the U.S. the financial positions or financial information of the U.S. persons. Now, in order to assist these FFIs in complying with the ordinance, the government has made this proposal. The government is suggesting that an IGA be signed. Let's say if there is no such an agreement, as long as all the FFIs sign the relevant agreement with the tax authorities, that will be the end of the matter. There is no need for an IGA. Is that right? Because it seems that the FATCA is requiring the FFIs to make such reports. Let's say if Mr. Andrew Leung is not in the financial services business, he is a trading firm, and originally FATCA doesn't cover his firm, but now after signing this agreement, the information covered not only includes tax information in the financial institutions, but also other information, even regarding the sale of tires. So will the scope of the agreement signed wider than that applicable to financial institutions? That seems to be the case. Now, we have been in the securities business for decades. I have tens of thousands of clients in Hong Kong, and some of the clients used to be Hong Kong citizens, but they became U.S. citizens without my knowledge. Then, do I have any responsibility to find that out? We'll come to that in a moment. Now, back to the scope. If this agreement is to be signed, shouldn't the scope only cover the financial information in respect of the U.S. clients, these FFIs? Thank you, Chairman. Now, 2 points of consideration. From the point of tax cooperation, an alternative to the CDTA is TIEA according to international standards. Parties holding the relevant information may not be confined to financial institutions. So in terms of tax cooperation, to align with international standards, we find it necessary to sign the TIEA. And specifically about the TIEA with the U.S., we have it is time critical that we comply with the Compliance Act. So there are 2 points of consideration. The TIEA is not only for the purpose of reducing compliance costs. This is just one additional point of consideration. But in the previous TIEAs, we have not confined the information to the scope of information to that held by a certain sector. And the flow of gathering information by the tax authorities under the TIEA is the same as that under CDTA. Perhaps Mr. Liu can supplement how the FATCA will be, how the FATCA interacts with TIEA. Thank you, Mr. Zhao, for your question. FATCA is an anti-tax avoidance mechanism unilaterally formulated by the U.S. to facilitate the tackling of U.S. persons setting up overseas accounts to avoid the tax authorities in the U.S. It will take effect in July 2014, and the Act requires that any FFIs report financial institution in respect of their U.S. clients to the tax authorities. Those who do not comply, the institutions which do not comply, will have to bear a consequence. The tax, the FFIs which pay withholding tax to the U.S. authorities will see that withholding tax being deducted because of this reason, and it will be subject to a 30% withholding on the payments made to it, and this is the unilateral tax avoidance mechanism approved by the U.S. Congress. It is a very aggressive tax avoidance mechanism, and that is why the government finds it necessary to sign an IGA with the U.S. for the sake of the financial institutions in Hong Kong as soon as possible. That is to say, the tax authorities is so powerful that they can apply a 30% withholding tax on all U.S.-sourced payments. Well, that's easy for new account holders. What about old clients, old accounts? We have no idea. Now, this is about the relevant tax laws in the U.S. But let's say, for example, if there's a financial institution in Hong Kong, if no information is available, there is no requirement for the FFI to gather extra information to meet the requirement of the U.S. authorities.
So, for example, a securities company had never asked whether the customer is a U.S. citizen, so he doesn't need to ask. And when the IRS asks for U.S. citizen accounts, there's no way they can identify, and therefore he says, "No, I don't know who is a U.S. citizen." So is that appropriate? So this will allow you to answer Mr. Cheung's question, and in fact, you are telling him some things according to Hong Kong law is this something that he needs to do? I'll respond from the IRD perspective, and Mr. Liu can respond IG. The TIEA is a platform allowing U.S. and Hong Kong Inland Revenue to exchange information. Now, under FATCA, Hong Kong financial institutions need to have an agreement with the U.S. government, the FFI. There's a foreign financial institution agreement, so each financial institution will have to sign that with the American government. So they still have to sign an extra agreement. They need to register. So this, strictly speaking, you can say they're not related. Well, but there is an urgent deadline. Let me explain where the deadline is. So assuming the Hong Kong financial institution is registered and the majority of customers will agree to disclose their information to the securities company, will disclose to the U.S. government through the securities company. But there are some non-consenting accounts. If they disagree, the financial institutions cannot submit the information to the U.S. So the U.S. government, regarding these who do not wish to disclose, they will ask the Hong Kong IRD, these people who do not wish to provide information, could you provide their information? So they will look through this TIEA platform. They will look at these non-consenting accounts. So these are the suspicious accounts. Hong Kong IRD has not required financial institutions, whether they are U.S. citizens. The Hong Kong legislation does not ask for special records. If they don't keep records, then they face a risk of the 30% withholding tax. I'll now defer to Mr. Liu. Under FATCA or the IGA, as a matter of fact, the financial institutions from the 1st of July need to register with American U.S. IRD. They have to also sign an FFI agreement. For old clients under FATCA, there are different ways of handling those. For old customers, if their amount is small, if the account balance is about below 50,000 US dollars, and if Hong Kong and US have signed the IGA, the Intergovernmental Agreement, the compliance costs will come down. They have a simple due diligence process where they go through the information they have on hand to see whether the customers are U.S. citizens. Have they left an American account, an American address, and they can confirm their relation with the U.S. and those have to be disclosed. And for large accounts, the financial institutions have to follow up with the customer to see if they are a U.S. citizen. They have green cards and so on. So it depends on the account balance and the tax evasion risk. So there are different ways of handling it. So financial institutions just have to comply with the due diligence requirement of FATCA. And if they comply, then they won't be liable to this withholding tax of 30%. Well, I haven't been able to take notes, and we need to be accountable to the public. Could you? So you're saying, even if they say they're not a U.S. citizen, but they left a U.S. address, they were born in the U.S., then you will suspect that they are an American. So it's not just asking whether they are an American citizen. There are other criteria. So could you provide this detailed information? Because if we ask them if they are American citizens, if they say no, are we liable? Does the security company is the security company liable? Mr. Zhang, you can come back after Mr. Zhong has asked this question. So what if they deny their U.S. citizenship? The financial institution has done their due diligence under FATCA. That's it. So you need to provide a list of what you mean by due diligence. If they deliberately conceal their identity, then they are probably a suspect of something. So in your due diligence requirement, in the account information, they need to might be required to take an oath at the Home Affairs Department. So, but when you open a securities account with Mr. Chung, they are not required to take an oath. So if you lie, you are already perjuring. So we are concerned about this due diligence. So Mr. Chung Gokpan, you have asked all my questions. I'd like to follow up. We're trying to coordinate our efforts with the U.S., but you might inadvertently affect companies not involved in finance. So I want to ask first, are you targeting U.S. citizens and companies registered in Hong Kong? But companies that do business with the U.S., they are, let's say they suspect there's tax evasion. So if the U.S. asks for this information, do we have to provide that? Then it's going to be the scope is going to be very wide. The second question, Ms. Kwan said Hong Kong government wants to sign a comprehensive agreement with the U.S., but the U.S. Is ignoring us. But if we were to sign a comprehensive agreement, what's the benefit to Hong Kong? Two questions. Chairman, first of all, regarding the tax information exchange, is it just limited to finance institutions, people holding information, or people who might hold information? Well, under the comprehensive information exchange, first of all, the requesting party needs to demonstrate that the information they are asking for has a relevant, reasonable relevance. What case you are involved in. They have to be legally authorized to get this information in their own country. They also need to provide a description about why Hong Kong would have this information and so on. For example, the dutiable terms, the IRS will have to consider these relevant criteria. So if you're talking about the scope, whether it would involve people outside of the finance institutions, the simple answer is yes. But this has not exceeded the bilateral arrangements, because if the other party was able to provide all this information, they could indicate the relevance, then in response to this request, the IRD needs to provide this information. And of course, we have to be in compliance with local law. Regarding your second question, under the comprehensive agreement, what benefits does Hong Kong have? I can give a broad response. And under the comprehensive agreement, first of all, we want to avoid double taxation. A lot of times, Hong Kong and other economic jurisdictions, if there's a trade and investment, there might be the same income that would incur taxes in both jurisdictions. So the first benefit is that if we can satisfy the tax requirements, we can avoid the double taxation. Another advantage is that under the comprehensive agreement, we have to clarify the right to tax, and there's also passive income such as interest, dividends, licensing income. Generally speaking, the Hong Kong taxpayer needs to pay a high tax rate, withholding tax of 20-30%. So under the comprehensive agreement, through the IRD negotiations, this withholding tax can be reduced, and these are actual benefits to the businesses. Well, there was an Italian order. There were some Italian companies that wanted to list in Hong Kong, Prada, and some Hong Kong people would hold stocks and have interest income. If we sign these agreements, it would reduce the interest tax. So Hong Kong people, if we have this agreement with Italy, the Hong Kong stockholder would have more interest income than other shareholders. Is this one reason? Like the Prada case, they will be able to recover less tax. So is that why the U.S. is not willing? Well, can you conjecture? So that the two governments are in discussion. So SAR has requested, they had rejected that request. Thank you. Over the years, we have been lobbying for signing comprehensive agreements with the U.S. So what considerations they have? I'm not targeting one trading partner. We have major trading and investment partners. We have also asked other partners whether we can sign the comprehensive agreements, and the experience we have is that there were some successes. We now have 29 comprehensive agreements. So those who are not interested in discussions with Hong Kong, past experience shows that they have their own local tax recovery considerations, and they also see that they would consider, if you want to sign a comprehensive agreement, are there double taxation examples? If so, they could think about how to resolve that. In the past, the different partners would have this consideration.
But objectively speaking, if we apply those which have signed CDTAs, then let's say there may be companies which have bought shares of Apple, there will be withholding tax, and after that, the authorities may. There may be withholding tax, and the dividends may be less. I don't know their reasoning. Well, I can say that the U.S. is the largest trading partner, and Hong Kong has close ties with the U.S. Despite the close trade partnership, the U.S. is still reluctant to sign the CDTAs with us. And from the government's analysis, that is the case, that they are not willing to sign the CDTA with us. And now they have this FATCA. Then why can't we do this? We just sign an agreement in relation to that U.S. FATCA instead of widening the scope to cover non-financial matters, so that we have something up our sleeve. We still have some bargaining power to lobby the U.S. to sign the CDTA with us. Otherwise, of course, they will have no interest to pursue the CDTA with Hong Kong. Thank you, Chairman. I understand the members' viewpoint, and from the sector, they've also expressed similar views. But like I said just now, there are 2 points of consideration. One has to do with FATCA, which is applicable to financial institutions, but in a broader sense, it's about tax cooperation or cooperation with other tax jurisdictions. And that is the TsyA, which doesn't just confine the scope to financial institutions. So to tie in with international standards on exchange of information, the TsyA, or the mechanism, should be established based on the OECD version of TsyA, so that we comply with the broader international standard of tax cooperation. I understand the point about broader scope, but what the government of the United States want is this area about FATCA. There is no need for us to expand the scope and to do more. The U.S. government is only asking for one thing, and why are we giving out extra? Now, let me put it this way. Is it the case that we want tax information in relation to some individuals in the U.S.? Is it because of that we need to have an exchange agreement? On a technical level, the TsyA allows either party to ask to make an EOI request, because our tax regime is based on the geographical area. Our scope is narrower, whereas for the U.S., it takes a global approach using the criteria of right of abode and citizenship, including resident alien. So exactly on this point, I share your view, Commissioner, because our system is based on the geographical area, whereas their system is based on citizenship. So if we sign an agreement that applies to non-financial institutions, I don't see an urgent need or a great need to do so. Whereas we must also bear in mind that we must bear the ordinary costs, and where state bear the other part of the cost, and we will it will be hectic for us. They have 300 million U.S. citizens. We have 7 million, and that system is based on green cards and residence alien. So in terms of workload, I don't know whether you'll be applying to the FC for funding to create more posts just to meet the requests from the U.S. Of course, I have the right to make amendments or propose amendments. Can you give us another paper in detail explaining to us that apart from financial institutions, what are the justifications for signing this agreement, which covers such a broad scope? I want to supplement one point, Chairman. As mentioned by Ms. Guan, we have two instruments of EOI only. The first one is the EOI provision in the CDTAs. The other is a pure information exchange agreement, TIEA. And these are the two instruments acceptable internationally. We have no third alternative. But it's just bilateral. We don't need to regard other jurisdictions. We can set the scope and narrow down the scope to financial institutions covered by the FATCA. I don't see the relevance with other tax jurisdictions. The TIEA is the TIEA model is one recognized by the OECD. It's not up to Hong Kong to make major changes to the TIEA. Yes, it's in accordance with the OECD. What if it's narrowed down? Does it mean it's not recognized by other jurisdictions? Now, in other jurisdictions similar to Hong Kong, they also signed TIEA or TIA with the US. That is for other jurisdictions. They also signed TIEA, which covers FFIs and other sectors. Let me put it this way. First of all, this is the internationally acknowledged standard. Secondly, even without FATCA, the agreement signed with the US is also based on the TIEA model of OECD. I don't get it. Does it mean that if you don't sign this so-called modeled version covering non-FFIs, they may choose not to sign it? And if that is the case, we won't be able to help financial institutions in complying with their act. If so, please put it in black and white. Because while scrutinizing this order, we need written replies from you. Dr. Kenneth Lau. Commissioner or PAS, please explain to us. Let's say in a scenario without TIA, in order to comply with FATCA, what would a financial institution in Hong Kong do? That is, without the exchange of information regime, without any agreement with the US, what steps would a financial institution in Hong Kong need to take? In your paper, please explain in greater detail. Maybe it has a huge impact on their business, or maybe it's not possible for them to do so. Please explain in detail. And the other point is the IGA and FATCA. The information exchange agreement is an umbrella that allows Hong Kong to sign an IGA with the US. And there are two models, Model 1 and Model 2. And as far as I understand, many jurisdictions across the world choose Model 1. And why have we chosen Model 2? Please also explain the difference. Thank you. Maybe you can tell us orally, what if the TIA is not signed and we have a lot of financial institutions in Hong Kong? Would it be cumbersome for them to comply with the US FATCA? And please explain this and give a brief reply now and give a detailed reply in your paper. According to FATCA, in order to reach an IGA, there must be an EOI arrangement. It could be by way of a CDTA or by way of TIEA, which we have now submitted to this Council for examination. These two is complementary to each other. So without TIA, simply put, there won't be any IGA entered into, which will lower the compliance cost of FFIs. Without this agreement, simply put, the FFIs will just have to register with the US, and on any EOI request, they can supply the information required. Why was it necessary for the agreement to be signed? There is a difference. That is, the IGA under FATCA provides certain provisions which will alleviate the burden on FFIs in due diligence checks, and there are also some exemption clauses. If the IGA is not signed, we won't be entitled to the exemptions. The exemptions allow certain FFIs in relation to some financial products, or they can be exempted under the IGA, and these products are not prone to be abused by for tax avoidance purposes. So if we don't sign the agreement, we won't get the exemptions, and it will be difficult for FFIs to comply with the Act, and the cost will, or the burden may increase. That is why we urge the government and the US to sign the IGA so as to lower the compliance costs and to alleviate their burden. And these are the actual benefits. Thank you, Chairman. Can you also explain the difference between Model 1 and Model 2 of IGA? I understand most of the jurisdictions have chosen Model 1. Why have we chosen Model 2? Let me supplement. Model 1 refers to FFIs outside the US reporting to their local authorities tax information, and then at the government level, tax information will be exchanged automatically. But I understand the existing legislation doesn't allow an automatic exchange of information. So unless the members allowed an amendment to the IRO allowing for automatic exchange of information, it is impossible for us to sign or to adopt the Model 1 agreement. As for Model 2, it has to do with any agreement reached with between the FFIs and the U.S. government. And with the client's consent, the FFIs will then supply information relating to the U.S. clients to the U.S. authorities. And then, if the clients do not consent to the supply of information by FFIs, the U.S. government can then, at the government level, make EOI requests for information to be provided by the Hong Kong government. And the tax authorities of both governments will then carry out an exchange of tax information. So, and these two are complementary to each other. Mr. Zhong? Thank you, Chairman. 2 questions. Just now, Deputy Commissioner Mr. Chiu made this point. Other OECD countries will sign this agreement, and they will not separate FFIs from non-FFIs. So, a point of information, which OECD countries have entered into such TIEAs, or are there any concerns expressed by these OECD countries?
The requesting country needs to provide foreseeable relevance information before Hong Kong IRD will accept the request. So these individuals or institutions, they are not aware that the U.S. government is asking for this information. But if they are made aware, is there any mechanism to safeguard them? They want to stop or prevent this information getting into the hands of the U.S. government. Do you have anything to protect them? We have already done this in other agreements. Thank you, Chairman. I can answer the second question. At the operational level, the U.S. tax authorities, they need to demonstrate the foreseeable relevance for the IRD to handle. At the IRD, when they ask for information or when they have information on hand, they need to comply with the ordinance disclosure ordinance, and there's a notice and review mechanism. So put simply, the information, when the IRD has prepared this information, they will notify the people involved and notify them that this information will be disclosed, and they can, within a statutory date, ask for a copy of this information, and when they have received a copy and reviewed it, and if there is some factual error, then according to the law, they can amend this information. So local legislation has a notification and review arrangement that there will be a disclosure and so on. Other OECD countries examples? Let me clarify my answer. The information exchange tools, there are only two. That is the comprehensive information exchange provisions and the independent exchange. So these are drafted by OECD. And U.S. is an important OECD country. The IRD, the U.S. Complies with the TIEAs, and they're not limited to financial institutions. So for the U.S., we are an exception and odd case. Yes, if we are successful in lobbying them, it would be remarkable. So put simply, you have examples of the U.S. and other countries who have signed TIAs. So you can provide Mr. Chung with that information. Of course, the countries that haven't signed TIAs, there are different possibilities, different reasons, because diplomatically you're not aware of their discussions. But if you're aware that the U.S. Has signed TIAs with 169 countries, so they're signing the same thing. So could you go through the list? Yes. I have a simple question for Mr. Liu. The financial institutions wants us to ratify this. They want the exemptions and so on. So if possible, could you provide their submissions, their views and so on? If you think it's not convenient, then you don't need to do so. I have considered that whether we need a hearing for financial institutions and non-financial institutions. If the financial institutions say well, ratify it as soon as possible, then at least we are aware of their sentiment. And up till now, we have not received any submissions. I recall that the Financial Affairs Panel, there were submissions, so we can look at the bill. It's Inland Revenue Amendment 2013. There were supporting submissions. You were a member. Okay. So next, Mr. Leung. The IGA status. You are signing information exchange. It's a subsidiary legislation that requires negative vetting in LegCo. But you also have an IGA. It's a government agreement. So the IGA, at the legal level, does it require negative vetting? Could you explain that? Under the IGA, the intergovernmental agreement, we have to rely on the information exchange order, and this will handle the Hong Kong government, U.S. government information exchange requirements. Now, the FATCA IGA, we're using the Model 2. This, we have to rely on financial institutions registering with the U.S. government, and they need to get an agreement from their customers, and this will have to be submitted to the U.S. IRD. So Hong Kong and U.S. will use that model to deal with FATCA compliance. So it's not directly related to Hong Kong tax issues. It's not a subsidiary legislation. The intergovernmental exchange will have to rely on the order. I'd like to ask the legal officer whether we do positive or negative vetting. Has the SAR government this is an IGA under the TIA. Do we have examples where the Hong Kong SAR government and other governments signed agreements that did not have to go through LegCo vetting? The Secretary has said that we already have the TIA framework and this EOI, and if we endorse it, if it's vetted, I just want to clarify what's the legal basis for that. So does the DOJ need to answer this? You're not asking, it's not relevant to the Bureau. So you're, in general, has the SAR signed agreements that need or do not need the Legislative Council to endorse? So you can answer later after further research. It's a profound question. Just now, Mr. Liu, I would expect a detailed information. Every financial institution needs to register with the U.S. It's regardless of whether it's endorsed by LegCo or not. Otherwise, they will withhold 30%. But then there are non-consenting accounts. So, in that case, we need to rely on the agreement. If the U.S. IRS will make a request for this information. So the basic principle is that if you have a non-consenting account information, will you rely on the mandatory powers to search them, or demand that you better give us that information? Will you do that? In actual operations, when we have non-consenting accounts, we expect that the U.S. government will put forward a request, and when the IRS looks at it and agrees, then we'll ask the financial institution, even we know that they don't agree, we'll ask what the actual situation is. And then we'll notify the person that we need to disclose your information to the U.S. Do you agree or disagree? Do you need to make any amendment to the information? So is it a mandatory power? We don't use mandatory powers a lot. The TIA is part of Hong Kong law, and the Hong Kong information holders, I understand that they are just complying with legal obligations. We have not used our mandatory powers. Of course, we do have these powers. Just now, you referred to due diligence. This involves a lot of financial institutions, a lot of SMEs, employees. They need to comply with Hong Kong laws and perhaps U.S. laws. So let's say an account holder, a Chinese person, we don't see a U.S. address, and so on. So if you comply with Hong Kong anti-laundering, money laundering requirements, you even photocopy his Hong Kong passport, mainland passport, but you don't know what his connection with the U.S. is. So now we have this U.S. Act. So perhaps we need to ask Ms. Kwan or Mr. Liu. So the Hong Kong Monetary Authority, will they require whether they have lived in the U.S., whether they studied in the U.S., whether they have U.S. assets, or whether they have a U.S. wife, a U.S. husband, an American husband, and so on? So will our monetary authority need to coordinate, or they don't need to? They just need to do the normal anti-money laundering, know your client to work.
And no extra processes will be taken, simply to comply with the U.S. requirements. Normally, the authority will require all FIs under its supervision to assist not to assist their clients in tax avoidance activities. This is important. And as pointed out under the relevant AML legislation, there are due diligence or diligence checks requirements. And this will help financial institutions to comply with the relevant laws in other jurisdictions such as FATCA. And under such tax avoidance mechanisms, for FFIs of the U.S., they may be subject to withholding tax, and the FFIs can therefore duly adjust their due diligence checks to meet the anti-money laundering requirements in Hong Kong laws or FATCA in the U.S. So some financial institutions, according to our observation, have actively asked their major clients whether they have citizenship in a particular jurisdiction, etc. I'm not asking about who takes the initiative. I'm asking about our authority or our Hong Kong government, whether they make it a mandatory requirement for FIs to ask the background of clients. Our usual approach is that we remind FIs not to help clients to avoid tax. That's number one. Number two, we remind financial institutions in dealing with the client's transactions, they have to deal with any requests from overseas jurisdictions. And they also need to meet the requirements of our major overseas markets, such as the U.S. But because this is not local legislation, we can only remind FIs to take note of the relevant requirements and see if any contravention of the local laws are involved. Mr. Liu, well, I can recite each and every sentence of your answer. So I have asked direct questions. Please give me a written reply directly. I cannot take vague answers. I don't understand. After passing this order, will I be compelling all the financial institutions, not just U.S. banks or the HSBC, but small financial institutions as well, to do much more to ask their clients many questions in order to meet the compliance laws overseas? We enforce the Hong Kong law, but the U.S. law, yes, that's correct, but you remind them not to help their Hong Kong clients to engage in tax avoidance activities, and not only tax in Hong Kong, but also in other jurisdictions. So give us don't give us a casual answer. I won't take a brief answer. I want an accurate answer, what this piece of legislation entails. Any other questions from members? Now, apart from the United States, which we will enter into a TIEA with, are there any other jurisdictions with which we will enter into TIEAs? And after signing the TIEA or TIA with the U.S., is there any possibility still of U.S. entering into a CDTA with Hong Kong? Because I have friends in the professional sector and in the business sector, and they would like to see an EICA signed with the US. Responding to the first question, whether the Hong Kong SAR government is discussing with any other jurisdiction on the signing of TIEAs, the answer is yes. Actually, in paragraph 4 of our brief, we mentioned the jurisdictions. The consideration is mainly on international standards. Our primary focus must be on CDTA, in particular in relation to our major investing and trading partners. However, there are those who, despite repeated persuasions, show no interest in pursuing a CDTA, and we have worked with the relevant chambers of commerce, etc. And ultimately, we need to sign the relevant EOI agreements, or we may fall short of the international standards. And we have started discussion with a number of Scandinavian tax jurisdictions on TIEAs. And the second question is, in the future, whether it is still possible or it is still hopeful that we enter a CDTA with the US. Our wish is very clear. But like I said just now, there were partners and they considered whether there were examples of double taxation. If so, they would consider pursuing CDTA. And for jurisdictions which we are negotiating with on TIEAs, we have been in touch with the chambers of commerce. For example, in Denmark, we want to save something up our sleeve so that in the end we can pursue a CDTA. But now we don't have any concrete examples, so we're somewhat limited in our lobbying effort. So I hope your paper will also include this point, footnote 2 of the electrical brief. Please help us understand better the U.S. Act. Now, a bank, I get it, broker-dealer, yes, they're regulated in Hong Kong. Custodian, I know. It seems that it's not covered by Hong Kong laws. It may be some subsidiary company belonging to a bank or a standalone bank, or it may be one of the trust companies or a company offering trust services set up by a solicitor's firm, and also engage primarily in investing or trading in securities. That is any non-U.S. entity engage primarily in investing and trading in securities. Now, sometimes there may be a non-U.S. entity set up and investing in, say, U.S. securities. And there may be, for example, venture funds, not publicly listed and not required to be registered with the SFC. And what else? Let's say there may be a publicly listed company in Hong Kong, and the securities in the stock market may be the capital or funds of its own company. It may be using its own funds in investing in securities. The company itself may be a manufacturing company, but it is covered and it is required to be registered. And you may not be aware of your involvement. Let's say if you then proceed with a trade, a garment trade of $300 million, let's say because of helping out a friend, you then have a consignment of garments, and then you're subject to a 30% withholding. Then you're in trouble because according to the U.S. Act, you fall within the category. So first of all, please help us understand whether this will be covered. And secondly, what will be the analysis and what is the impact on Hong Kong? The U.S. government should publicize to other jurisdictions its act. So it will be strange for the Hong Kong government to publicize the U.S. act on their behalf. But without publicity, they will stand to gain because of the 30% withholding. Let's say I have a textile company, and I have been really in the textile trade for years. And then I invest in U.S. securities, and then because of 300 million LC, I am subject to a 30% withholding because I haven't registered. So, Ms. Guan, from this perspective, please consider about the entities listed here, bank, broker-dealer, etc. How do we tell them that they may be required to be registered, or they may become non-consenting accounts and may be subject to a 30% withholding unless you have no dealings with the U.S. counterparts? You may be subject to these risks. So maybe you should remind these institutions not subject to the regulating authorities' supervision. Mr. Zhong, I want to ask, I happen to want to ask these questions as well. In particular, in paragraph 25 of the electrical brief, the administration should review on a regular basis the such agreements so that we will not be Hong Kong taxpayers will not be affected by such agreements, and we should also be ready to raise specific questions on the implementation of exchange agreements with the counterpart, and that is what we're talking about. This agreement targets financial institutions, and we're asking whether non-FIs can be will fall outside the scope, and that is what Chairman asked just now. Would you like to give a brief reply first? Yes. To reassure Mr. To, the IGA under FATCA refers to financial institutions, and there is a detailed definition what is meant by depository or financial institution. And Mr. James To mentioned a trading company or a garment factory. Then it is if it has investments. First of all, it is not a financial institution. So to reassure Mr. To, the major business is not investment, and it is not investing on behalf of clients. It is not defined as a financial institution. So I will give you more details in the paper. So in English,
broker, dealer, custodian, or trust company. Or, they are common to all.
And you've also included all.
In securities. So
that means it may not just refer to financial institutions.
Investing.
So yes, originally I ran a garment factory, but now I have, after decades of business, I have $300 million, and I am engaging in the trading of securities. So my primary business may be garment, but I have no longer been engaging in the business. I may have accumulated profit of millions of dollars, and I give dividends to shareholders. So that is still my primary business.
投資唔係為自己。
We need to add that you are investing on behalf of customers. The financial institutions are intermediaries. We could make it clear they are investing on behalf of customers, the banks, securities companies. So if they can set up a private fund. It depends on whether they are investing on behalf of customers. If it's 4 people, 4 brothers have formed a company, there are only shareholders, 4 shareholders. They are investing for themselves, not for customers. So you have to give us a detailed definition. So let's conclude here today, and we'll wait for your information, your response. The legislative timetable. Thank you, Chairman. Please refer to the relevant timetable. It will take effect on 20th of June. There's a subsidiary legislation. The vetting deadline is 28th of May. So on the 16th, this Friday, we need to make a report. And of course, you can decide whether to extend the scrutiny period. And it would, if you extend it, it would end on 18th of June. But you need to bear in mind that if you extend the scrutiny period, we could do that in the 2 council meetings on 21st and 28th. But we're now we're now vetting the appropriation bill. So it would be after that. So if we can't extend, 28th of May is the deadline. So the government can work us, do their best. So the next meeting will need to, we'll have to set the next meeting before 21st of May. When we need to report to a House committee on the 16th. We can also air our difficulties. It's beyond our control, including the budget. So we can schedule it for the 21st for extension, and if we can't deal with it, it will automatically be extended to the 28th, and so on. So we'll slot it for the extension period, and we are concerned that it might not be extended because it might not be tabled, and therefore we'll have to hold meetings. We'll have to report to the House Committee, and we can meet after reporting to the House Committee. I had wanted to give you more time, but it's quite urgent. Do we need to set the next meeting date as well? We have a lot of members absent, so perhaps you can liaise with the government and we can mark the diaries. We only have 3 people now anyway. Okay, thank you.